Be ready. Start. Gian Chand and Dhanbir instituted a civil suit for declaration that late Hardei had gifted the land to them during her lifetime. Wide gift deed bracket exhibit PW3 oblique A bracket clause, which was registered with the Sub-Registrar. Stop. They were put in possession of the land. Stop. Keshav in connivance with defendants number 2 to 6 had got mutation recorded in his favor, which mutation was wrong and illegal and did not affect their rights under the gift deed. Stop. They had prayed for within bracket small I decree of declaration that they were owners in possession of the land within bracket small 2I a decree of permanent injunction restraining Keshav and others from interfering with their possession of the land and within bracket 3 in case they are disposed from the land by the defendants during the pendency of the suit. A decree for possession. Stop. Keshav and other defendants contested the suit on several grounds, including validity of the relied upon gift deed. Stop. The suit preferred by the plaintiffs was accordingly dismissed. Stop. Civil appeal preferred by the plaintiffs before the district judge was also dismissed, with the first appellate court evaluating the evidence on record to affirm that the execution of the gift deed in favor of the plaintiffs was a delusion. Stop. The second appeal preferred by the plaintiffs was allowed by the High Court, reversing the concurrent findings on the ground that the trial court and the first appellate court had misread and misinterpreted the documentary and oral evidence. Stop. We need not refer to the reasoning of the High Court, as this court in civil appeal set aside the judgment and remitted the matter to the High Court for fresh hearing after framing of an appropriate substantial question of law. Stop. This court observed that the substantial question of law so framed by the High Court was vague and not proper. Stop. The gift deed satisfies the legal mandates of sections 122 and 123 of the Transfer of Property Act 1882, and being a registered document, it enjoys presumption of truth. Stop. Para. The concurrent findings of the lower courts delve into the context and factual aspects surrounding the primary evidence, namely gift deed, to conclude that the plaintiff's case lacks base for a bona fide claim for decree of declaration. Stop. Appreciation of evidence is an exercise based on facts and circumstances where the preponderance of probability can take varying form and configurations. Stop. What facts and circumstances have to be established to prove the execution of a document depends on the pleas put forward. Stop. Ordinarily, no one is expected to sign or execute a document without knowing its contents, but if it is pleaded that the party executing the document did not know the contents thereof, then it may, in certain circumstances, be necessary for the party seeking to prove the document to place material before the court to satisfy it that the party who executed the document had the knowledge of its contents. Stop. considering that the very origin of the gift deed was disputed by the executant during her lifetime, the lower courts were right in weighing the evidence of the gift deed on the touchstone of its validity first rather than its form and content. Stop. The fact in issue in the present case is the voluntariness and animus necessary for the execution of a valid gift deed, which is to be examined on the basis of evidence led by the parties who could depose for the truth of this fact in issue. Stop. Decision and determination of the fact in issue is by examination of the oral evidence of those persons who can vouchsafe for the truth of the facts in issue. Stop. The impugned judgment in the second appeal by the High Court unfortunately choose to ignore and not deal with the fact in issue in the background of the case, but was completely influenced by the evidence led to support execution and registration of the document, and not whether execution was voluntary and in exercise of unfettered will to effect gratuitous transfer of land in favor of the plaintiffs. Stop. When a person obtains any benefit from another, the court would call upon the person who wishes to maintain the right to gift to discharge the burden of proving that he exerted no influence for the purpose of obtaining the document. Stop. Corollary to this principle finds recognition in subsection within bracket 3 to section 16 of the Indian Contract Act 1872, which relates to Pardanashi ladies. Stop.